As you know, this is our last CBD meeting for the year. There will be many more next year as well. We were going to talk strictly contracts tonight. However, we were going to talk about the new BC4, which was supposed to have been released ready for this month, but unfortunately didn't. So what we're going to talk about is changes to the Home Building Act, which will commence on the 1st of April. If time permits, we might do some discussion on the liquidated damages and have some question time. There's an assessment form there, so as usual, if you fill it in, please, hand it in at the end and you'll get your CBD receipt. For the members, you will receive a diary tonight. Non-members will get a calendar and a pencil, and of course all members will get that as well. Now, I'd like to introduce you shortly to Robert Riddell from Gadens Lawyers. Gadens are specialist construction lawyers with close associations with the Master Builders Associations, including being the Legal and Contracts Committee, the Property Council of Australia and the Institute of Arbitrators and Mediation Australia. Can I please ask you to welcome Robert? Thank you.
Thank you, Alan. Just a word in relation to BC4. It is being renovated at the moment. For those who don't know what BC4 is, it's a construct-only residential building contract that's supposed to comply with all those more detailed requirements of the Home Building Act. So it's a pretty safe product for those who are working on residential building projects. We've been involved, the Legal and Contracts Committee at the MBA meets out there at Forest Lodge, which is near Sydney Uni, once a month, and we're slowly going through the old BC4, which is a contract form that has been around for some time, and it's chopped and changed and had bits taken out and new things put in, and we've ended up with a document that's pretty inconsistent and really needs a renovation. It's been not a lot of thought has gone into a lot of the changes, so we're trying to give it a good old work over. We're probably 3/4 of the way through, a committee of 10 people who are working on it, so it really is sort of management by committee and taking a long time to achieve. We were hopeful that might have been finished, that process was finished, and we might have something to say about BC4, but if I were to go on about it at the moment, it may well be that the changes that I described to you aren't actually implemented, so it could be a waste of time. However, there are some things we can talk about, well, I can present to you. I propose, if my clicker, I propose to cover a couple of areas, and it depends on how long I'm taking, unfortunately. Give her another click. There you go. I wanted to talk about, when I say the Act, it's the Home Building Act. Who amongst us is doing residential building work? Can I just get an idea? Good, so it's a relevant subject. Most builders are going to be involved in residential building work to a degree. However, there are, of course, licensing and insurance issues that may temper your enthusiasm for that type of work. The other thing I wanted to talk about, done a good job of that, haven't I? Testing 1, 2. Yeah. That's better. So I'll ask Mr. Finger to have another click. Home Building Act, Amendment Act 2008. It's going to commence operation soon, so you should probably know about that. And the final thing, if time permits, is Liquidated Damages 101, which is a presentation we've been doing throughout the various regions of the Master Builders Association. It's a presentation that takes 20 to 30 minutes, depending on how fast I approach it and how long we have to go. Just get an idea. What time is it now? Okay, because I just want to keep a tab on how long I've been going for. I don't want anyone to pass out from boredom while we're in that. Now, just as a matter of housekeeping, if you want to jack up and say something about something I'm saying, please do. I find it much easier, it's easier for me if it's more an exchange than a sort of just a pure presentation by me. So if you've got a comment, an observation or a question as I'm going along, put your hand up and give me a yell, and we'll see if we can address it and work it. I'm prepared to be as flexible as possible. So, I want to talk about liabilities under the Act, but to understand the Act, the Home Building Act, we've got to know what it relates to. And it relates firstly to residential building work, and that's work in relation to the construction or alteration of a dwelling. That's a central term. Specialist work, home building work relates to specialist work, and there's those various categories of specialist technical work. And we've got another one there. Specialist work in relation to a dwelling is also residential building work. Now, work that's not residential, that's work that's not on a dwelling, and work that's not specialist can be carried on in New South Wales without a licence issued by the department. And of course, the builder's licensing is administered in New South Wales by the Director General of the Office of Fair Trading and the Fair Trading Corporation, the builder's friend. Somehow I don't think so. Now, carrying out residential building work and specialist work, the Home Building Act requires that anyone who carries out residential building work, or specialist work in New South Wales is to be licensed to carry out that work. Further, if the work's residential building work, the Home Building Act's consumer protection provisions will apply. And that is that it'll require home warranty insurance if it's above a given value. It will require a written contract that complies with the Home Building Act's regulations, and the Act will imply certain warranties and other terms into your building contract. So broadly speaking, residential building work is work in relation to the construction of a dwelling or making alterations to a dwelling, repairing, renovating, decorating or protective treatment of a dwelling, so even your painters' trades are caught by the net. And a dwelling is interpreted very widely. We get questions from time to time about whether the work we're doing is actually work on a dwelling and whether it should be covered by the Home Building Act. Now, it includes part of a building containing one or more dwellings, stairways, passageways, rooms that are used in common by the occupants of those dwellings, together with pipes, wires, cables, ducts, that are not for the exclusive use of the dwelling. So if it's shared, sort of mixed development, and dwellings are serviced by the wires or whatever we covered by the Home Building Act. And residential building work includes parts of a building containing one dwelling only, and stairways and passageways and the like to provide access to the dwelling. So that's parts of mixed developments where parts of the premises are used for service or access to the dwelling. That'll be included in residential building work. And that's what that second part is. Can I just go back to that, sorry? Non-residential parts of a building containing one or more dwellings give support or access to the residential part, so that those structural elements of the non-residential parts, they are covered by the Home Building Act. And there's a few more bits and bobs: driveways, paths and paving, retaining walls, fences and gates, and that's about it. Now, there is exempt work. The Act does provide for work that's not included in the Act. It doesn't include a boarding house, a guest house, hostel or lodging house, residential parts of a hotel or motel, accommodation that's specially designed for aged persons with disability or children, but that doesn't include self-contained aged care accommodation, residential parts of a healthcare building that accommodate staff a house or unit designed or constructed or adapted for commercial use as a tourist, holiday or overnight accommodation, and any part of non-residential building that's constructed or adapted for use as a caretaker's residence. So the construction, alteration, repair, renovation and decoration, even protective treatment such as paintwork, of any of the items that we've described above that are not exempted from the Act, well, it will be covered by the Act, of course, and equally the exempt work is not subject to the operation of the Act. And the main ones, those are the boarding houses issue. It comes up a lot. There's quite a few around it in terms of boarding houses. If you have a look around, it's surprising how often it comes up. Educational institutions are a big one as well, exempted from the Act, as well as that aged care exemption. If the value of the work that's to be performed doesn't exceed $1,000, you don't need to worry about the Home Building Act. It won't apply. It's a very low threshold though. How many contracts or how much work have you done recently? So if you're just going to repair a window frame or paint a door frame or something like that, it may not cover, almost doesn't cover the cost of getting to the site, does it? If the work requires a licence under a different Act of New South Wales Parliament, then it probably won't apply. Now, if a registered architect or a licensed builder is already supervising the building work, then it won't be necessary for the person performing that work to enter into the form of contract and comply with most of the provisions let me put that again. I've put that incorrectly. An architect who's supervising the work is exempt from the Home Building Act. The second category is, if all of the residential building work is being done or supervised by the holder of a contractor's licence, then the subbies are not required to comply with the contract requirements under the Home Building Act. It's for the head contractor to be concerned about those. Yes, I have a question.
One of the big issues you have as a builder, especially when an architect would be supervising a job.
Perhaps I should give you this.
One of the big issues you have as a builder, especially if the architect is supervising a job, is the fact that what they want is not feasible sometimes, and you'll say to them, no.
Excellent. Okay.
And then they'll say, but I want this. And then you say, well, you take liability.
May not comply with the code. Yeah, it may not comply with the standard. You've raised that point. Hold on to it because we go directly to that point in a moment. It's a big issue. And it is something that's addressed in the Home Building Act, so we'll get to that. Now, the Home Building Act implies certain warranties into contracts for residential building work, as you're probably aware. And we'll run through these quickly. It's that the work will be performed in a proper and workmanlike manner in accordance with the plans and specifications, that the materials will be suitable for the purpose for which they're used, the work will be done in accordance with and will comply with the Act or any other law, the work will be done with due diligence and within the time stipulated in the contract, and if no time stipulated, within a reasonable time, whatever that is. And the work will result to the extent of the work conducted in a dwelling that's reasonably fit for occupation. And the work and any materials used in during the job will be reasonably fit for the specified purpose or result. Now here we are, liability for defective design. This is the question where you, as the builder, you're taking on responsibility for the design, but the homeowner or the architect or the superintendent is requiring you to build something that you know doesn't comply with the Home Building Act, or something that doesn't comply with the Building Code of Australia, or something that doesn't comply with applicable standards and the like, or it won't get you through the required standards of tolerances and the like. You know that it's not going to be good building practice. It's a big issue, but there are some ways of dealing with this issue. There is an answer to it, I'm pleased to say. Section 18F of the Home Building Act provides that where there are court proceedings, and that's tribunal proceedings in the CTTT or proceedings in the district court or maybe even the Supreme Court if it's a big claim, that it's a defence for the defendant, and that would be the contractor, to prove that the deficiencies which the plaintiff complains arise from instructions given by the person for whom the work is done, contrary to the advice in writing of the defendant, that is the contractor, or the person who did the work. So that if you get a direction for a variation, for example, and you know that it's not going to comply with the code or it's not going to comply with applicable standards, and you put that in writing and you ask the homeowner or you ask the homeowner's agent or representative or superintendent or whoever's looking after the homeowner's interests, you put them on notice that it's not going to comply and they instruct you to proceed in any event, well, you want to keep that letter, maybe even get them to sign at the foot of it, but that they acknowledge receipt of it, because it might be something that you'd be very useful in defending proceedings later on when you're blamed for the fact that the work doesn't comply with the BCA or the standards. Now, that's the first line of defence. The second line of defence is Schedule 2. HBA means Home Building Act, just shorthand. Nothing like a few acronyms floating around. Now, the contract can limit the contractor's liability for defective design. So if you've got it in your contract's allowed to limit the builder's liability for defective design issues where the failure relates to a design or specification prepared by or on behalf of the owner. But your contract needs to state it. You're not taking on responsibility for the design or specifications which are prepared by the owner. If you don't state that in your contract, you probably are taking on liability for the specifications and the design, even though they're not your specifications and design. It's a pretty bad deal, really, isn't it? Now, a design specification that's required by the owner, well, let's start again. The contractor can limit the contractor's liability for defective design where the failure relates to B, a design specification required by the owner if the contractor has advised the owner in writing that the design specification contravenes a BCA or the development consent. So it's sort of repeating, in a way, the provisions of 18F. Yeah, come on.
What if it's unsafe? What they want to do is unsafe?
Well, usually that would mean that it doesn't comply with the BCA, but it'd be a good idea to put that in writing to the owner. And you wonder how they'd get it through the certifier in any event if it's unsafe. He's probably going to pick it up and not give you an occupation certificate, or the trades aren't going to issue certificates in relation to it if that's the case. Somewhere in those many checks and balances and all the red tape and bureaucracy, hopefully it'll get picked up. But if you're mindful of it, you'll be able to point it out to the necessary people. But there's nothing like covering your own back either in terms of putting it in writing to the owner saying, we have a problem with the design that you're putting to us. It's unsafe for the following reasons. Do you want us to proceed? It's at your risk, basically. We probably don't, as the contractor, don't recommend. Yes?
You say design specification.
Design or specification.
It doesn't have the and in there, and I just wondered whether...
Yeah, either.
Either. Or.
Yeah. Scope, basically. Well, scope's doesn't quite get us there though. Could be lots of things. So, any further questions in relation to covering one's back where you're concerned about directions that you've been given? We hear, just before that, the classic story that we get is, the crazy architect has required that wall tiles be placed on the floor. We know they're not going to be good enough, they're going to crack, they're not going to last the distance. We know there's going to be claims. What do we do to protect ourselves? Well, that's the procedure. That what's been specified is not really fit for purpose. That's the case. Get the owner to sign off on that. Get the architect, who's probably the owner's agent, to sign off on that, and then you're covered. Really, so long as the owner or the owner's representative knows and you've had it signed off.
What if the owner and the architect...
I'll give you this. Gives me some exercise too.
What if
I won't sing.
or the architect doesn't sign that? What do we do? Do we just walk away, stop the contract, walk away and don't do the job?
If you put it in writing to the architect and you say it won't comply with the Act, you've covered your back. You want us to proceed in any event, that's okay. It's just me as the contractor, It's not my risk. You know it. I've discharged my duty to you, homeowner. It's all about consumer protection, the Home Building Act. But even consumers are supposed to be able to make up their minds about things if they have enough information. If they want to shoot themselves in the foot with some bodgy wall tiles on the floor, well, that's their issue. That's a very simple example, of course. It gets more complicated than that. Now, who's heard of home warranty insurance? Hey, we love it. It's good stuff, isn't it? Don't you wish you were an insurer? Wouldn't you love to write those policies? So, Section 92 of the Act. So it prohibits a person from doing residential building work under a contract to a value of $5,000 or more unless the work has been insured under a policy of home warranty insurance. If the insurance is not taken out, then the builder may well be providing the homeowner a ground not to pay claims that are due under the contract. It makes it much harder to enforce your payment claims if you haven't got the insurance in place. So, Section 92, this is about you're not even permitted to demand or receive payment under the contract for residential building work from anyone else unless you've got the blessed insurance in place. And certificate of insurance in the prescribed form, that's something that issues from the insurer or the broker, has been provided. Bit of speed things up, I think. Is it a hint? Look, breaching that provision carries a maximum penalty of what they call 100 penalty units. Penalty unit's $110, so that's $11,000. That's a maximum penalty, though. You go before the magistrate, you can probably convince him to charge you less. It's not my fault. He made me do it. Your worship. But you'll get fined something, and the more times you get fined, the greater the fine will be until you get to the maximum fine, if you've still got a licence by that time, that is. So 94(1) attempts to disentitle builders from claiming a quantum meruit as well as claiming what they're entitled to under the contract. Often when there's no building contract, an option is to claim a quantum meruit, which basically means a fair price for the work that's been done. It's a cause of action, as us lawyers call it, in equity. It's another approach, another strategy to get paid. Now, until 2003, the Home Building Act provided you can't even have a quantum meruit if you haven't got your home warranty insurance in place, so it was pretty bloody strict. It could be a disaster, it could put you out of business, particularly if you were too exposed in terms of outstanding claims. Now, so in 2003 it was ameliorated by the addition of subsection 1A. Here we go. I think we need to... There we go. Despite section 92(2), and that's the one that disallows the contract, disallows you to claim any money, if a court or tribunal considers it just and equitable, the contractor, despite the absence of the required contract of insurance, is entitled to recover money in respect of work on a quantum meruit basis. So it's in the court's discretion. You'll probably get away with it once. After that, you probably won't get away with it again, and you'll be left unpaid if you haven't got your home warranty insurance policy in place for the building work that you're doing. There might be other things that are considered by the court. The court might have a look at your spotless record at the Office of Home Building after doing a licence check and see that you haven't had any other claims brought against you or any fines and the like. That'll stand in your favour. But if you've got less than a perfect copybook, you might find that the court decides that it needs to teach this recalcitrant builder a lesson, and you'll be left perhaps without payment for work that you've done on the materials that you've supplied, which can be a very unsatisfactory outcome for obvious reasons. So, home warranty insurance is third-party insurance, not first-party insurance. A builder doesn't get the benefit of a home warranty insurance policy. Clause 42 of the Home Building Regulation sets out who must be a beneficiary under a policy, and broadly, this is the person on whose behalf the residential building is done. Basically, usually your client, your customer, usually the homeowner. Sometimes they're developers. So in terms of people who are not required to be beneficiaries under the contract of insurance, a developer who does residential building work, a person who does residential building work other than under a contract, i.e. a spec builder, is not going to be a beneficiary, is not going to be somebody entitled to claim under a home building, under a home warranty insurance policy. A holder of a contract or licence who or which carried out the residential building work, so that's just clear that you can't claim under the policy for your own work, and companies related to the licence holder that did the work. So really that pins it down to the homeowner, and it's the homeowner and their successors in title, anyone they sold the property to, basically. Yes?
What about the builders? If you're a builder, you sell the house, is the owner of the house that buys it, will they get homeowner's warranty?
That's, yes. The question is, will somebody who purchased it off a builder who developed it himself, will they get the benefit of the home warranty insurance policy? They're known as a successor in title, and they will be entitled to claim under the policy if they ever get to the stage where they're entitled to claim, which is something that we'll be getting to briefly shortly. Now, this is more in terms of legal rights, but if anyone were interested in learning more about who is and who isn't entitled to claim under a home warranty policy, that would be the case to look at in the most recent statement. So if a payment is made under a home warranty insurance policy to a homeowner, that's not necessarily going to be the end of the story, unfortunately, because the insurer is going to look to the builder to be reimbursed for the money that they've paid out. Of course, the insurers will often require at the pre-qualification stage, or at the stage where they're issuing you with certificates of insurance, to put up security. Now they'll look to the security, whether it be a bank guarantee or whether it be even a mortgage over your home. There might be other forms of security that are suitable to the insurer as well. They'll go to that first of all if they have to pay out on claims, because that's the easiest for them. It's there, particularly if it's a bank guarantee. They'll just go and present it to the bank. You may not even hear about it until after the insurer's been paid the money to reimburse it, what it paid to the homeowner. Now, the insurers often require indemnities not just from the licence holder, but also from the licence holders. If the work is done through a company, they'll require indemnities from the other directors of the companies. The insurers will try to get whatever security they can, because it's much easier to call on security than it is taking somebody through the court to enforce the claim. Often the builder, upon receiving a claim from an insurer for reimbursement, if the builder learns about it and the insurer hasn't already helped itself to the bank guarantee, but often the builder will assert that the insurer paid too much, that the insurer failed to ensure that the homeowner mitigated its losses by getting a reasonably priced contractor to come in and rectify the defective works or completely incomplete works. Many and varied defences can be raised, and the upshot of this is it's always worth taking advice. If you find yourself in that position and the insurer's having a shot at you, make sure you get advice in terms of what the insurer is claiming, because I don't know any builders, apart from some pretty sophisticated developers who are really all over the issue. It's a very specialised area, this subrogation in the context of the Home Building Act. It's a great idea to get some advice. Now, a classic example of this is where Big Corp is involved. Does people here know who Big Corp is? It's called the, anyone know Big Corp? It's called the Building Insurers Guarantee Corporation. And it was an entity that was set up after those wonderful events in 2000 when when the Adlers decided to give up the ghost and HIH and FAI went into liquidation. Everybody realised the whole thing was a bit of a ruse, and the HIH empire collapsed in on itself. And as a result, a lot of homeowners were left without an insurance policy for the home warranty insurance. The legislation required them to take out this policy. HIH was by far the largest provider. Well, HIH and FAI combined. FAI was a subsidiary by that time of HIH. So they were the main providers of this system that had been established by statute and was apparently being monitored by the government and was supposed to all be there for consumer protection. Well, of course, it fell to bits. HIH were issuing these policies as fast as they could, but they weren't paying out on any claims. It was just part of a revenue gathering scheme that they had, which is continuing to this day, and I'll get onto that shortly. Now, when that happened, there were many hundreds, if not thousands, of homeowners who were left without, who had claims in terms of breach of the statutory warranties that I talked about, but didn't have any funds. So the government paid, well, has by now, or has certainly paid at least $350 million into Big Corp, possibly more, and it's just been a fund that's created to pay out claims under the HIH and FAI policies. Now, the Big Corp is set up and governed also by a section in the Home Building Act, and that provides that Big Corp can recover amounts paid out by it under a claim against the builder. Well, it can recover sums paid out from Big Corp to the homeowners against the builder who performed the work. Now, one of the reasons I say that it's worthwhile having a good look at claims that are made against you by a builder, by the insurer. If the insurer is making a claim against you, have a good look to see whether the claim is reasonable and whether the insurer overpaid or didn't protect the builder's interest, that is, didn't mitigate the loss, is that in the financial year 2005 to 2006, Big Corp actually paid out on 217 claims. And there are further 528 claims that were under assessment by the end of financial year 2007. Haven't released any figures since. I've got nothing more up to date. Well, not that I know of anyway. Now, one of my colleagues, Craig Blackwell, has noted in a construction alert that he produces for his clients, and I just happen to be on the mailing list, that given the extensive recovery powers awarded to Big Corp under the Home Building Act, they have an estimated recovery rate of 2% on what they pay out. 2%. And that indicates that virtually all builders, developers or guarantors against whom Big Corp have a right of recovery have either been wound up, or either bankrupt or dead, or have insufficient assets to make recovery by Big Corp not commercially viable. Now, we know that's not actually the case. Many of them will have been wound up, but there's still a larger proportion who are still trading. And the figures indicate that the actual claims, that the reimbursement from the builder to Big Corp for the amount that's been paid out is just a tiny fraction of the amount that's being paid out by Big Corp to the homeowner. Again, I stress that it's worthwhile having a look at these insurers' claims if they're making them against you. There seems to be a lot of scope to negotiate that claim down. If Big Corp are only paying out they're only recovering 2%. Boy, there's plenty of scope to negotiate down the claim that's made against the builder. So there's a low theoretical probability of Big Corp achieving full recovery under a home warranty insurance policy against even a solvent builder. Now, how far are we in? How are we going for time, Helen? All right. Home Building Act, Amendment Act 2008. There's been lots of publicity recently in relation to problems homeowners have encountered with home warranty insurance. And I think it'd be a fair call to say it hasn't been all that complimentary. The main complaint relates to the fact that home warranty insurance is insurance of last resort. That means that the homeowner is only permitted to claim if the builder is dead, has disappeared, or is insolvent.
I've started a service where we kill the builders.
You could certainly argue that as a useful service in terms of consumer protection, but I think some of those present today wouldn't be all that happy about it.
I know of a case where Vero has paid out, the builder is still working,
Yep.
not bankrupt, not dead, and they paid out. They didn't give him a chance to go back and rectify the work. There was some sort of a dispute of when he could get in and do it.
Yep.
The owners were not happy, and they paid it out.
Common
a
issue.
similar amount, and they claimed a whole lot of it.
Common issue. The issue is that the insurer against whom the claim has been made has not permitted the builder, whose work is alleged to be either defective or incomplete, to come back onto the site to complete the work. But they've had the work performed by others at potentially much greater expense than the builder would have incurred by doing it himself. I can't work out why they do that unless there is one possible reason. If the policy was written before 1 July 2003, the insurance at that stage was not of last resort. You could make a claim under your home warranty policy when the defect became apparent or when you had the problem with the builder. You didn't have to go and get your builder, make your builder bankrupt or send your builder insolvent. The last resort came in 2003, so maybe the insurance policy with Vero related prior to that period. There are instances subsequent to 2003 where Vero have stepped in before the builder's been sent bankrupt. I'm working on one in relation to a developer in Maroubra, not a developer, a builder in Maroubra, who it was 120 units and defects have been alleged in relation to most of the units and almost all of the common property. Huge claim. And Vero have paid out $4 million under the policy. But my client's still trading, still building, still doing resi work. So I don't know what the forces were at play that resulted in Vero making that payment. But this work was done subsequent to the commencement of the last resort regime. So I've got no idea why they're making that claim. Yes, up the back.
I thought once someone made a claim against your licence, you can't get any more homeowners warranty anyway.
It's not a claim against the licence because all sorts of claims are made, of course. It's actually, if directions, part of what the changes to the Act have a bearing on that. So can we just hold that question for a moment because we actually get to that. It's a good question and we'll be covering it so you'll know what the position is in relation to where orders have been made. So this last resort thing where you've got to send the builder insolvent or the builder has to have died if it's an individual or disappeared, that presents a significant hurdle to your mums and dads homeowners to claim under these policies. If the builder fails to make good the homeowner's complaints, then the homeowner has to commence proceedings, and that might be in the CTTT, the tribunal, or it could be in the local or the district court. Supreme Court seems unlikely because that only really cuts in after about $750,000, so hopefully we don't see too much residential building work in that jurisdiction at a mums and dads level. We'll see that in terms of developers, but I'm trying to focus more on the mums and dads level because that's where the problem lies. So the homeowner must be successful in those proceedings and then be awarded a judgment in a sum of money. Now, assuming the builder doesn't comply with that judgment in the sum of money, the homeowner must then take the builder to either the bankruptcy court, if the builder's an individual, or to the winding up court, to the Supreme Court or the Federal Court, and wind the builder up. So it's not until the builder's actually been wound up that the homeowners are actually allowed to lodge a claim with the builder. I mean, that event might be years after the defect became apparent. The other issue is that the homeowners have had to fund maybe $100,000, maybe $150,000 worth of litigation, particularly if it's been defended by the builder. So this is a very inaccessible form of insurance. It takes a lot of effort, a lot of heartache and a lot of time, a lot of money before the consumer or the homeowner can make a claim under the policy.
I've got one now where the builder developer has disappeared. He's gone to Hong Kong, and Vero won't even talk about it because they've got his mobile phone number and they can ring him in Hong Kong, so he hasn't disappeared.
Yeah, so it was a company? No, it was an individual. Have they commenced the proceedings against him?
Yes.
And what's he doing about that?
No idea.
I'd just push it through to judgment. If he's in Hong Kong, he wouldn't be able to defend it. He'd have to come to Australia to defend the proceedings.
Well, that's
yeah.
probably what's
It's still unsatisfactory. The homeowner shouldn't have to do this. You know, it's hard enough to buy a house in Sydney. You know, it's an extraordinary impost. It's the biggest purchase you'll make. And then you've got to add on $150,000 or $200,000 in terms of legal fees before you actually can recover on the insurance policy. It's a great deal for the insurers because so many people just think, oh, I can't be fucked. You know, I can't be bothered to do it. I've got better things to spend my money on. I'm going to sell the house and move on and forget about it and just be more careful with whom I deal with in the future. So it's a great deal for the insurers. Anyway, now the total indemnity limit under that home warranty insurance policy is $300,000, but that includes the amount you can recover for your legal costs. So if you spend $150,000, you've only got $150,000 left to cover the defects. So if the place is a wreck, the indemnity is not going to get you there. We're seeing a lot of cases now with cases of big material defects to the structural defects to the premises where what's left over is just insufficient to cover. So that, again, the homeowner is left out of pocket. Home warranty insurance is justified. The imposition of home warranty insurance is justified on the basis of consumer protection. Well, that's the spin anyway. But to be entitled to a payment from an insurer, you've got to go through an extraordinary series of hoops and hurdles and wait years for payment. There's no form of insurance like it. It's unique. There's no other mandatory form of insurance that puts you through these type of hoops. It's really unparalleled in its inaccessibility from a consumer protection perspective. Now, to rub salt into the wound of home warranty insurance is the super duper profits that the insurance companies are making out of it. It may come as a surprise to some to learn, and others it probably won't come as a surprise to learn, that the premium income is 800% of what they pay out in claims. 800%. It's not a bad deal if you can get it. I think we need to start gauging insurers. Yes?
You just mentioned that would be a surprise to us.
Possibly not. See. Yeah, well, this is not an ABS issue. ABS is an alternative scheme, and maybe the underwriters know about that, but this is not directed as criticism of ABS. It's criticism of a scheme that ABS is really was a new device for builders to try to get access to home warranty insurance rather than having their residential building businesses going to the wall because they couldn't access the insurance, because it was just to get the insurance it was so inaccessible, and it was really being well, the supply of the insurance was very short. Nobody wanted to underwrite it for a while, and that was due to it was all really flowed out of the 7/11 or 9/11 attacks, and there was a big insurance meltdown occurred. Anyway, moving on. I've been talking about these 2009 changes to the Home Building Act. Well, I better let you know what they are. The main thrust of these amendments will be to introduce a new trigger to home warranty insurance policy. So trigger means a new entitlement for homeowners to claim under the home warranty insurance policy. But it's certainly not good news for builders, I'm afraid. The change has been enough for the state government to put a spin on things, to say that it's doing something to free up the system, but in my view it will fall well short of remedying the fundamental problems with this junk form of insurance. To understand the new trigger, one first needs to understand a new section 42A that's entitled Automatic Suspension of Licence for Failure to Comply with Order to Pay Money in relation to a building claim. Doesn't that just warm the cockles of your heart? So in a nutshell, section 42 provides that if a licence holder fails to comply with an order of the court or an order of the tribunal, the CTTT, so it's an order to pay money, if the licence holder fails to comply with an order to pay money, by the date that money was required to be paid, the licence holder's licence is suspended. Now that's not currently the position, but now it's going to be automatic, and the suspension will take effect 28 days from the due date for payment of the money order. Now, there's a few ways, if you're not happy with the judgment that gave rise to that money order, you're entitled to appeal. And B is the second part. Oh, come back. Now, where the licence holder appeals the court or tribunal order within a 28-day period, the suspension will be withheld. It won't take place. But it will take place if, and the outcome of the appeal, that original decision was confirmed. So if the appeal is unsuccessful, the suspension will take place right away. If the appeal is successful, then there will be no suspension because there's no order, because the appeal will overturn the order. So it's as if the order never existed. Now, you've got to get a stay. If the holder appeals the court or tribunal's order, but that's not quite the full story. You've also got to get a stay of execution on the judgment. But a stay, if you're appealing a judgment or order and you have some reasonable grounds on which to appeal, a stay is not difficult to get, but it is an additional application that a lawyer will have to make. So if you get that stay, then the suspension will be delayed, or it won't come into effect. The suspension itself will be suspended. Technical?
Is there any way that the builder can enforce his right to carry out the work? Because what happens in most cases is the owner says, well, I don't trust him, I don't want him near my place. And therefore you've got all the costs of the other builder's profit and overhead, and you've got GST and so on, which if the builder went to do it himself, none of those things would apply, and you're talking probably 25%.
So what you're saying is, can you get an order for, as a builder, as a contractor, can you get an order for specific performance of the building contract? Can you enforce your building contract? Because one of the rights you have under your contract is to enter upon the site and perform the works. The answer is no.
No.
Doesn't happen. It's a contract of employment. Courts are very reluctant to grant orders for specific performance of a contract for services. It's not the type of contract that the court will. They'll enforce damages and the like, but they won't enforce the performance of the work. If you don't want the builder on there, you can exclude them from the site.
So the owner can just say no?
Basically, yeah. It may be to the owner's financial detriment to be doing that, because the owner may be wrongfully suspending the works and the builder may incur damages and losses and costs and temporary hire costs thrown away, and materials might be turning up and going off and the like. But the only remedy the builder would have would be in financial terms rather than the right to perform the work. It is an issue that the Fair Trading were considering in terms of a rewrite of the Home Building Act that we were all promised would be enforced by now. However, it was all last year we were promised that by about April, and then it was August, and then it was September, and now it seems to have gone dead. But there was a full rewrite of the Home Building Act that was going to revamp the builders' rights under the contract to give them that right to get back on site to complete the work in a economic manner. But unfortunately, the state government have been a little distracted recently. Forgotten where we're up to. 42A. Okay. So we know about the suspension. I want to talk about the new trigger. Oh, hang on. Well, 42A is not the new trigger. 42A is that the Director General may, by notice in writing to the licence holder, defer the operation of the suspension of the licence for any period up till the date on which the licence is due for renewal. So forget about the appeal. You've got a money order against you as a contractor. You don't want to appeal. There is another avenue. The Director General has a discretion to delay or defer the operation of the suspension of the licence. In all of the legislation and the Hansard that I've read in relation to it, that's the transcript from Parliament, they don't explain this provision, and we've been trying to work out why. What we think it probably relates to is where your builder has a number of other residential building projects on foot and that are going quite fine. If you were to suspend the builder's licence, then you would suspend all of the work that's been performed by that builder across the board. And it may be that you will prejudice other projects, and it'll have a cascading effect throughout all of the various sites that are run by that builder. So that's about, or maybe also there's a loony member of the tribunal, or the decision or the determination simply doesn't make sense. But you'd think that'd be something that'd be dealt with or addressed through the appeal process. There might be some manifest injustice that has impressed the Director General to the extent that he's prepared to defer the suspension. So, moving on. Now, back to do with what has this got to do with home warranty insurance, which is a fair question. Now, there's a new section 99 through these 2009 amendments, and that will include the suspension of the contractor's licence under section 42A. That is, if a contractor doesn't pay a money order by the court, or by the CTTT, that will be a new trigger entitling the homeowner to claim under the home warranty insurance policy. So the effect is that the homeowner doesn't have to take the builder to bankruptcy court. The homeowner gets its judgment, his or her judgment, and at that stage, the homeowner is allowed to make the claim. The homeowner doesn't have to take the builder through the bankruptcy court. The homeowner doesn't have to wind up the builder. A saving of maybe 1.5 to 3 months in time, a saving of maybe $10,000 in costs. Overall, a fairly marginal change. It's a movement in the right direction, but what it doesn't represent is the fundamental reform to the last resort insurance. Homeowners are still put to the potential of hundreds of thousands of dollars of litigation before they can claim under the home warranty insurance policy.
Who makes this judgment? Who gives the final blessing? So if the tribunal makes the judgment, that's it?
That's it. You can always appeal it. Well, no, you can't always appeal it. You've got to have grounds to appeal. You've got to identify some defects in the, they've got to be arguable defects. And you'll file your appeal and it'll be heard by now the Supreme Court of New South Wales. We'll hear the appeals from the CTTT. They no longer go straight to the Court of Appeal. I've got one at the moment where it was in the tribunal for a hearing that went for a couple of weeks, and then it took the member of the tribunal about 9 months to issue a judgment, and then the builder appealed it in the Supreme Court, lost, went down like a ton of bricks, an absolute sack of potatoes, and to prevent the claim being paid to our client, then decided to appeal again to the Court of Appeal, so appealing the Supreme Court decision. Just goes on and on and on. This bloke, his name is McFadden, and he was actually featured in the Sydney Morning Herald a couple of months ago. For anyone who read his tale of woe, he's been going for about 2.5 years trying to claim under his home warranty insurance policy. But he's one of the poor homeowners. The extent of his indemnity is only $200,000 because his policy was taken out a number of years ago. I think it was in about 1st of January 2007 that it went up to $300,000, the indemnity limit. Don't quote me on that date, but it's somewhere around there. So he's probably spent more in legal costs than he'll recover under the policy, which is very sad, really. It shows a dysfunctional, it's supposed to be consumer protection. So the insurance remains junk insurance. Fiddling around the edges proves little except to demonstrate that the insurance is really hopelessly flawed and that the state government really is out of its depth in this area. The problem's not a new one. The problems with home warranty insurance have really been hemorrhaging since 2000 when HIH and FAI collapsed. But unfortunately, Macquarie Street has been far more focused on their internecine struggles and purchasing marginal support rather than addressing fundamental problems. And we're seeing this across such a range of areas at the moment in terms of the legal services that we provide. I mean, security of payment is another logjam where there's, if they understood the system, the changes that they could make could just a really beneficial effect on the way the system operates. Anyway, in terms of home warranty insurance, would anyone like to know what I really think? It's a great system, but yeah. But let me say, I know this ABS is putting this on, but it's not an ABS issue. ABS provided builders with an alternative system. It was a great thing that occurred. I'm not critical of ABS, and ABS didn't set up the system, and ABS won't be. They may be able to make submissions in relation to the problems to the system, but it's going to be, of course, more an advocate from the builder's side of the equation than the homeowner's side. But I think it's useful that you know these things. A question?
Will they ever go back to the old system where they ever go back to the old system where you put your DA in and you paid 0.5%? You always used to pay 0.5% for long service leave and 0.5% for homeowner's warranty at council.
Yeah, we're still paying for the long service leave.
Yeah, but you don't pay the 0.5% for the homeowner's warranty. Remember that?
And that was in the sort of days of the Building Services Corporation, wasn't it? That was a system that worked,
Yeah, that's what I'm saying.
That was a system that worked. It was slow. It was a bit old-fashioned, but it worked, and that's the system that they renovated, and they are working really well in Queensland, where the system is under control and the whole system is integrated in terms of licensing and insurance and defects rectification and the tribunals. It's all really almost run out of the same shop, but it's not. There's a bit of separation of power you need between the tribunal and the insurer. Otherwise, you may not get the best outcome.
The only thing that's happened is your insurance is basically 1% now in cost rather than 0.5%.
Yeah.
So the 0.5% is going to somebody.
Yeah, well, you're lucky if you're getting it for 1%. You're doing very well.
1.1 or whatever it is.
Yeah.
But it's like somewhere along the line, the insurance companies have got an extra 0.5% out of this.
Yep. Mm. So look, that's it in terms of insurance. How are we going for time? Are we going to put these poor gentlemen through the liquidated damages show, or?
Maybe just 10 minutes on it, perhaps.
Okay. I can be a bit creative with it, perhaps. Are there any other questions so those amendments to the Home Building Act, this is academic, and every policy that's written before 1 April 2009 will not contain the new trigger. That's in the transitional provisions. So what have we got? What's the next slide? Got a bit ahead of myself. It's probably the best, you know, I think we've covered it fairly thoroughly and don't need to drill into it more than that. So, contracts with liquidated damages clauses. Do we see those much in the... Are we having principals imposing liquidated damages? Does anyone know what I'm talking about? Yep. Quite a common thing to have, particularly in contracts where you're acting for a developer. Maybe not so common in mums and dads contracts. In fact, you'll be trying to avoid them. I imagine it'd be a great way to strip the margin out of the job if something goes wrong. So they're imposed by a principal on a contractor, generally as a result of the contractor's failure to achieve practical completion in accordance with the provision of the contract or provisions of the contract. So I'll be dealing with various issues in relation to the imposition of liquidated damages and the circumstances in which the principals may lose the right to liquidated damages. So liquidated damages are really an entitlement for the principal to claim damages for late completion. And they're generally going to be in a fixed daily rate. So it might be $500 a day, it might be $10,000 a day, depending on the size of the contract. And they act as an inducement to performance. So if you've got liquidated damages, you don't want to incur them. And they also regulate the consequences of non-performance. Something to watch out for. I'm going to jump around a bit here because I really don't want to read this whole paper. It's going to drive me nuts. I had to read it the other night, so I'll try to do this a bit ad lib. Something to watch out for in liquidated damages clauses. If you're the principal, probably good if you're a contractor, if you decide you don't want, if the contract has a provision for liquidated damages, has a clause in there about liquidated damages, and you decide, oh, we don't want to go liquidated damages, we'll put nil in the schedule for the daily rate. Trouble is, if you do that, liquidated damages are usually the only entitlement for compensation for the delay. So if you put nil in as your daily rate for liquidated damages, you won't get any compensation at general law. So you've really got no remedy whatsoever for late completion, or no remedy in financial terms at least. So if you put $0 per day, that's it. You can't claim a reasonable amount saying, oh, I didn't want liquidated damages, I just wanted the general damages that you're entitled to for late completion on a contract. Liquidated damages are probably good from a contractor's perspective in, well, one, maybe not so good, but one benefit is at least they act as a cap on the amount that the principal can claim. At least you're able to do some sums and work out how much, you know, you're potentially up for, or what figure you're going to start with and negotiating it down. Do be careful in the contracts that if you've got liquidated damages, make sure that that liquidated damages rate is the only entitlement to delay damages, because I'm seeing contracts where they have a liquidated damages, but they also have a carve-out entitling the principal to claim any additional costs, such as damages if an agreement for lease doesn't reach its sunset date, or damages, losses that the owners can incur from third-party claims and the like. Just be careful. A tip with liquidated damages clause is to make sure that the liquidated damages represent the exclusive right for compensation for delay. They can also be useful, liquidated damages, for contractors can find them useful in that with your subbies, you can back-to-back your subbies with the same amount of LDs that you're required to pay under your head contract. And, you know, in theory, that provides you with a bit of insurance that if the subby is the cause of you being late, then at least you've got that back-to-back and you've got a claim, drag the subby into the dispute. Now, a corollary to liquidated damages is the daily damages figure in the contract in relation to damage for delay that the contractor is not responsible. So delay damages. We all know about delay damages. It's a very, very common claim, particularly in the security of payment context. So why don't we see daily rates being stated for the contractors entitlement for compensation for delay. We don't often see that saying that if the principal holds up the job, the contractor is going to be entitled to delay damages at a rate of $10,000 a day, do we? We don't see that. Now, I was thinking that it's probably less attractive concept for a contractor because there's going to be some stages of the work where that $10,000 a day or $1,000 a day rate will represent your loss on the job. But there's going to be other stages of the work where your claim might be much more than that, or your claim might be much less. I think from a builder's perspective, it's much more difficult to be comfortable with a daily rate figure for your delay damages because your financial exposure throughout the job varies so much as the job progresses. Particularly given if there's separable portions and the like. There's going to be some stages in the job where it's going to cost you a mozza if the principal holds you up. There's other stages of the job where you're probably not really going to care. How do you strike that correct rate? And I suppose also that the principal is your client and you don't want to discourage the principal from entering into a contract with you. And perhaps having a daily rate for builders' delay damages is something that won't help in terms of marketing, in terms of landing that order. Those are the categories I was going to talk about. So, generally speaking, the courts have held that liquidated damages will not be enforceable in situations, see how we're going, yeah, okay, where the amount of liquidated damages is construed as a penalty, the contractor is prevented from performing its obligations as a result of the Principals Act, that's called the Prevention Principle. There's no fixed date from which the damages can commence to run. The superintendent fails to grant an extension of time within a reasonable or fixed time, or the contract is terminated before the right to liquidated damages has arisen. If you're the contractor and your contract is terminated before you reach completion, liquidated damages become academic and can't be claimed. You've got to get to practical completion before you can start measuring liquidated damages. Now, there's this issue about whether the daily rate is a penalty or not. It's an allegation that's often made by the contractor that the daily rate is a penalty. Now, the only entity that's entitled to levy a penalty is a government or a statutory authority. If you've got a penalty in a contract, it's unenforceable. So, to not be a penalty, the daily rate has to be a genuine pre-estimate of the daily loss. Now, that's a genuine pre-estimate that's made before the contract is actually signed. So it's a bit artificial, but there's no reason why a principal can't sit down and work out how much additional interest it's going to pay for every day that the builder is late, or how much rent am I going to lose if the premises are not completed by 30 January. So they can work out a daily rate. And the court will look at the figure in the context of the circumstances at the time of the contract rather at the time of the alleged breach of contract, that is, rather than at the time of the delay. So the court will look to see whether at the time that daily rate was established, was that reasonable? And it'll ask whether it's a genuine pre-estimate of loss. And if you are in the position of a principal, it's a great idea to prepare yourself a note of how you got to your daily rate and bung it in your file. Date it and sign it and bung it in your file. It might become an exhibit in proceedings to enforce your liquidated damages. Now, your pre-estimate doesn't have to be precise. It just has to be a fair shot at it. It doesn't matter if later on it was shown that your pre-estimate wasn't accurate. It's not actually relevant. Also, the fact that if no loss was actually suffered, say interest rates fell to zero, and you did your calculation based on a 5% interest rate or a 10% interest rate, doesn't matter. You'll still be able to enforce that daily rate of liquidated damages. It's only where the nominated figure is so far in excess of the maximum conceivable damages that could have flowed that it may be construed as a penalty.
Does the owner have to declare how he arrived at his daily rate?
If you're alleging that the daily rate is a penalty and couldn't possibly represent a genuine pre-estimate of the loss, the owner will need to establish in its defence how that rate was established.
He doesn't have to do it at the time of contract?
Should do it. It's a great idea to do it at the time of contract, because if you can show that it was a genuine pre-estimate of the loss, it won't be a penalty. Won't be a penalty if it's a genuine pre-estimate of the loss, as opposed to a penalty. I've got a case example. It's a case, State of Tasmania and Leighton Contractors. We've all heard of Leighton Contractors. The parties had contracted for the design, construction and maintenance of roadworks, requiring the realignment of a highway to bypass a town in Tasmania. Numerous problems with the site, and there was considerable delay. A clause in the contract provided for payment of liquidated damages at the rate of $8,000 a day in the event of non-compliance by the required date. The delay in completion was from April to November. So a shitload of money was levied by way of liquidated damages, $1.7 million. Leighton sought to challenge the figure as a penalty and drilled into the detail of the calculations, which demonstrated that the allowance was on the high side and represented a quantum of loss that the state was actually very unlikely to suffer. Now, nevertheless, the provisions of the contract were upheld on the basis of existing legal principles. That is, that by looking at the date of the contract, the magnitude of the project, the potential losses that may have been suffered if you were considering it at the outset, then the sum was not completely out of proportion to any loss that may have been suffered. So the Leightons were unsuccessful in trying to overturn the liquidated damages of $8,000 a day, despite the fact that it was well in excess of any loss that was actually being incurred by the state by that time. So we've dealt with other ways of losing the right. If you have a liquidated damages a claim against you, always consider that if they fail to insert a date for practical completion, that'll be very helpful for you, because you'll have no commencement date for them to run. Probably unlikely though. There are contracts which have preconditions to claiming of liquidated damages. You'll always want to make sure that the principal has complied with those preconditions. And there is, of course, the prevention principle. The prevention principle is that you're not entitled to liquidated damages if you're a principal, if the principal, that is, you were responsible for the delay. The only circumstances where that might occur is where the contract has a working, operable, reasonable provision entitling the builder to claim extensions of time. If the contract hasn't got extensions of time provisions in it due to principal delay, then you may have a very good argument against the imposition of liquidated damages on the basis of this prevention principle. I had a thought there that was... Anyway, it'll come back to me. The good news is we're almost finished. So, I know what I wanted to say. These acts of prevention by the principal, the law has developed in the last 15 years so that it's not just the principal's acts of prevention that need to be addressed. If a superintendent on a job holds you up, the contract should entitle you to an extension of time. If it doesn't, that will be, or may well be, an act of prevention that will give you a defence to a claim for liquidated damages. If there is an act of prevention, what happens is time is set at large. There's no fixed date for completion. Completion is simply to be in a reasonable time. And then it's impossible to calculate liquidated damages on that basis. So delays, say for example by a neighbour who gets an injunction to prevent you continuing on with the works, not necessarily your fault, maybe the neighbour didn't receive the notices from council in relation to the development or something like, or there's some stop order that's not issued as a reason of the builder not complying with the contract. That will probably also be an act of prevention. It certainly could be an act of prevention that will has the potential to set time at large and provide the contractor with a defence from a defence to a claim for liquidated damages. So, in summary, you'll be glad to hear, check whether liquidated damages is a cap or not, and by that I have a look at the contract and make sure that the only entitlement in the contract for compensation for contracted delay is liquidated damages. Beware of carve-outs. Beware of clauses entitling the principal to claim things in addition to the liquidated damages. Very unfair, really. Press for a cap on liquidated damages. That is, that liquidated damages be limited to, say, 5% or 10% or 15% of the contract sum. You don't want to go out of business as a result of liquidated damages if you can help it. You could easily lose your margin. Margins are getting slimmer with time, and particularly in these economic circumstances, so a cap on LDs is really very sensible. You say, I'd love to do your job, but I don't want you to send me to debtor's prison. You know, I've got a business, I don't want to go out of business if something goes wrong on the job. Yeah, don't sign the contract, yeah. That's a big call, I know. But yeah, well, at least go in with your eyes open. If you can always take on a commercial risk. As long as you know you're taking on the commercial risk, you're in a much better position than not knowing that you're taking on a commercial risk, I think. Go in with the eyes open. At least you know you could got that in the armoury. You can say, well, 15% of, you know, just say, by crikey, that's, you know, $150,000 in any event. What, you know, isn't that going to compensate you? Acts of prevention, make sure there's a good extension of time regime in the contract. That is, if liquidated damages are being claimed against you. If there's not a good operable extension of time regime, that may give you a defence. And just check that the principal has complied with all the preconditions to claiming liquidated damages in the contract. Oh, there's more summary. Do tell. This is more for principals, I suppose, but this is about retaining that calculation. Retain the sum that gave you your daily rate. Could be for contractors as well, of course, if you've got subcontractors with liquidated damages in the subcontract. And importantly, always when you've got an extension of time circumstance, keep up your paperwork. Make sure you make the claim in time. Don't do yourself a disservice by letting your administration of time-related issues fall apart, because you may well have a lot of trouble trying to put it back together again when you need it, or you might find that you haven't served notices and you're now time barred by the terms of the contract or general law from serving notices. And that's my name and address.
All right, Robert, thanks very much. Gentlemen, can we put our hands together for Robert? Thank you.
Thank you. Pleasure.